Good day, everyone. Just as a show of hands, can you just raise your hand, anybody, just to see that firstly I'm in the correct session, and secondly you can all hear me. Thank you, Yolanda. Thank you, Witness. Thank you, Kaylin. Thank you, Alzona. Mabato, can you hear me? Cool. Thank you, Mabato. So once again, good afternoon, everyone. Thank you for making it to this session. Just as protocol, before we start, we will paste the link to the attendance register to the chat of this meeting. So once you click on it, it will open a page. You just need to confirm your details and attendance on this class. We should do another one during the session, and towards the later of the session, we will paste the link again for the attendance register and also include the link to the feedback form just for you to give feedback for this session. Any feedback is welcomed as long as it's going to better our session, regardless if it's negative or positive. That is now the feedback. So I will get straight to today's session, and also just to confirm, we are recording the session for future reference. I'll start sharing my screen. Just to confirm, we in the AUE1601 legal aspects and accountancy. Housekeeping, just a reminder to switch off your video, to mute your mic. Should you want to ask any question or give a comment, you're more than welcome to either raise your hand or just unmute, and then we can have the conversations. Remember, these are supposed to be interactive sessions, so any comments or questions is welcome. And as confirmed regarding the attendance register and feedback form, you will be seeing messages on the Teams chat. And for any study support related queries, you can send an email to ctntart@unisa.ac.za. Firstly, we'll just on what we're going to cover today. We'll firstly recap on what we did for the previous session, our to-do list or homework as we'd like to call it, and then we'll get into the crux of today's session, which is topic 2, records required by companies. Specifically on what we're going to cover today, it's more of application, it's more of going into the Companies Act itself, also going to the companies regulation, which is in addition to the Companies Act. So if you do have a copy of each, you're more than welcome to open it in the meantime. But I will also still be sharing a screen of it and going through what we'll be covering today. So we'll first start off by recapping the previous session. But before I do that, let me just quickly log on my phone so that I can have the session on this side as well to make it easier for me to see if there are any questions asked since I'm sharing the screen. Okay, so we can proceed. So we dealt with the Companies Act 71 of 2008 and the regulation to the Companies Act, and a brief intro to it. This is on the preface, Roman 5, which says, the Companies Act deals with the formation of a company, accountability and transparency, fundamental transactions, share capital, and business rescue, just to name a few, and the regulation to the Companies Act of 2011. This is to explain the applications of the Companies Act and provide more information where necessary. So as I said, what we'll do today, we'll touch both of those documents so that we can see the correlation between the two. We also dealt with related and interrelated persons and control and subsidiary relationships. This was more on how do we identify that an entity is controlled by who and how. The main crux of the conversation we had regarding the activity was question E, where the question asked we had two people who are not married but were living together for quite some time, and they had two kids. And when we referred to the Companies Act as confirmation, I think it was section 2.1, it confirmed that according to the Companies Act, a long-term relationship is seen as marriage. So you don't necessarily have to be married in that instance, to be regarded as married, but the Act does provide a provision to be regarded as married. And then we also looked at solvency and liquidity test. So for solvency, this is where we looked at our assets greater than our liabilities, meaning that we'll be solvent, or our assets less than our liabilities, which will be insolvent, that is for the long term. And for liquidity test, we looked at the non-current or the short term, where we asked we will be able to pay off our debts within 12 months from the period we acquired them. And if the answer is yes, then you are liquid, and if not, you are not liquid. I do have an extract from MoneyWeb, which we will look at just shortly, just to sort of like see practicality, for liquidity tests. Also, if you remember, we did touch on when these tests are done. For example, share capitalization, at share buybacks, or when a director needs financial assistance from the company. We also looked at the categories of companies, which is profit and non-profit. If I can just scroll through that. Specifically, we covered profit companies, which is state-owned, public companies, private companies, and personal liability companies, and this is contained on page 7 of the study guide. We also looked at the Memorandum of Incorporation, which is a founding document of the company, what it entails. For example, how will we, depending if it's a public or private, will we have a company secretary? Are we going to appoint auditors, and so forth? Also remember, with the Memorandum of Incorporation, as much as it forms a basis from the Companies Act, but it also includes all the other aspects that are not included in the Companies Act. For example, if it's a private company which is not obliged to have auditors, auditing their books, but a decision can be made by the directors or the shareholders that we do require, auditors to oversee the functioning of the business if it's efficient and effective. So it's always sort of like in a rule amendment to what the Companies Act is stated. We also looked at pre-incorporation contracts. This is section 21. We will just look that into detail. So what I will do is now I will go through section 21 of the Companies Act, and I'm going to open that document so we can have more emphasis on it. Can I just get a thumbs up from Yolanda just to confirm that you can see this document? Okay, can anyone confirm that they can see this document that I'm sharing? Okay, you can't see it. Okay. Let me do this again. Okay, I think now you should see it. Yes, okay, correct. So let's go to section 21. I'm just going through because the page numbering is not correct, so I just have to scroll down. Okay, so as you remember when we spoke about pre-incorporation contracts, so it's when the company had not been incorporated already, but then you enter into a contract. What are the circumstances surrounding it? And we'll just have a look at what we covered last time and see what the Companies Act is giving in detail. We will also go through to the regulation to the Companies Act, section 35 or regulation 35, to see what is contained on that document. So under pre-incorporation contracts, it says a person may enter into a written agreement in the name of or purport to act in the name of or on behalf of an entity that is contemplated to be incorporated in terms of this act but does not yet exist at the time. A person who does anything contemplated in subsection 1, which is this section, is jointly and severally liable with any other such person for liabilities created as provided for in the pre-incorporation contract while so acting if the contemplated entity is not subsequently incorporated, meaning are liable if the business did not actually become incorporated, or after being incorporated, the company rejects any part of such an agreement or action. So now this is after the fact. The contract is enforced, the company has been incorporated, but now you are saying that no, you are no longer, let's say, for example, going to lease those premises. The owners, a person who does that incorporation, or the people who do that incorporation, which are called the incorporators, are jointly and severally liable for the debts or the liabilities incurring from that contract. If after its incorporation, a company enters into an agreement on the same terms as or in substitution for an agreement contemplated in subsection 1, the liability of a person under subsection 2 in respect of the substituted agreement is discharged. So this is where now the contract becomes enforceable. The business is in operation. Any debts in relation to any pre-incorporation contract will be for the company. Within 3 months after the date on which a company was incorporated, the board of that company may completely, partially, or conditionally ratify means to confirm, or reject any pre-incorporation contract or other action purport to have been made or done in its name or on its behalf as contemplated in subsection 1. So what it means there, it's a pre-incorporation contract. You enter into a contract to start leasing a building from January 2021. Tomorrow the business becomes incorporated. You've got 3 months to either confirm that you will still be continuing with the contract from January 2021, or you can reject that contract. Subsection 5, if within 3 months after the date on which a company was incorporated, the board has neither ratified nor rejected a particular pre-incorporation contract or other action purported to have been made or done in the name of the company or on its behalf as contemplated in subsection 1, the company will be regarded to have ratified that agreement or action. So it's just confirming subsection 4. You are given 3 months to confirm or to reject a contract before it becomes enforceable. If the 3-month period passes and you have not confirmed nor rejected, then that it means the contract is in operation or is enforceable. Let's look at number 6. To the extent that a pre-incorporation contract or action has been ratified or regarded to have been ratified in terms of subsection 5, the agreement is as enforceable against the company as if the company had been a party to the agreement when it was made. The liability of a person under subsection 2 in respect of the ratified agreement or action is discharged. Just confirming that with that 3 months that you are given, if the company now is incorporated, they have not confirmed nor rejected the contract, it becomes enforceable. Once it's enforceable, all the liabilities become of the company. So the person or the incorporator will no longer be severally and jointly won't be jointly and severally liable for the debts of the business pertaining to that contract. Number 7, if a company rejects an agreement or action contemplated in subsection 1, a person who bears any liability in terms of subsection 2 above for that rejected agreement or action may assert a claim against the company for any benefit it has received or is entitled to receive in terms of the agreement or action. So it's a case where you are about to incorporate a company, you get into a contract, but for some reason now, let's say now the board has been elected. For some reason, they do not want to form part of that agreement or that contract you signed before it was incorporated. Then the incorporator has got a right to claim against the company for any liabilities if the contract was rejected. So basically, before we go to reckless trading, I thought I should just touch more to give more clarity on the pre-incorporation contracts. What I will do, or what we will do now, is to go through an activity just to see the application of pre-incorporation contracts in relation to what we discussed last week. So still remember, this is a recap of what we did the last time. So please look at activity 1 on page 11. I'll start reading so long. You are an accountant and must advise Lionel Lester and Wendell Webb, who have made an appointment to see you about a private company they want to form. The company will operate from a factory which they believe will be suitable for the lease. The owner of the factory wants to tie up the lease as soon as possible. Lester and Webb asked you the following question. Is it possible for the proposed company to enter into the lease contract before the company is incorporated? Now with this module, it's more about practicality. So you're going to see the way that this has been answered, and this should be the way that you should start structuring your answers. So number 1, it says, in terms of the Companies Act, which is section 21, Lester or Webb may enter into an agreement in the name of or on behalf of the proposed company. Number 2, within 3 months after the date on which the company is incorporated, Lester and Webb, as the board of the company, must ratify, meaning they must confirm the contract. If they do not actively confirm or reject the contract will be deemed to have been confirmed. If for some reason the company is not incorporated, then Lester and Webb will be jointly and severally liable for all liabilities, for example, the lease payments arising from the agreement. If the agreement is confirmed, it is enforceable against the company, and Lester and Webb's liabilities as individuals are discharged. That is, the contract and performance in respect thereof will be between the lessor and the company. The pre-incorporation contract must be in writing, and you will see the bold words in that solution are the keywords when you are giving your response or answer. Any questions on this before we move to reckless trading, which we also touched a bit when we did the previous session? Any questions on pre-incorporation contracts?
Okay, I just wanted to confirm. So, the people who draw up the pre-incorporation contract, it's just basically a confirmation of what's been already discussed. So the people who enter into the agreement are the ones liable until the company is formed and the company actually accepts the contract, right?
Yes, yes. So just to put it in another way, what you've just said, let's say today, me and you, we decide to start a company. We enter into a contract. We're leasing a building. Me and you, we have up to 3 months to confirm whether we are carrying on with the lease or we are rejecting the lease. If we do not confirm that and the company does not become incorporated, meaning that it doesn't exist, then me and you are jointly and severally liable for the debts of that contract or the liabilities of that contract. But if within 3 months we incorporate the business, now the business exists on its own, we have up to 3 months to confirm we have up to 3 months to confirm that that contract is in existence. If now the 3 months comes and the company has been incorporated, the liabilities won't be me and yours, but it would be of the company. So basically what we're saying is here, me and you are representing this entity, which has not been in existence as yet. But the moment it becomes existent, we need to confirm to the landlord that yes, we are continuing with the contract. In that instance, there won't be any liabilities on me and you. It would be on the company. But if still the same case, the company is in existence, but now we do no longer want to lease those premises, we need to inform the landlord within 3 months after that date the contract was signed that we are rejecting that contract. I hope I made putting it another way made it easier to understand.
Yes. Also, I wanted to know, is it assumed that the person who entered into the contract is now also a part of the board once the company has been set up, created?
Not necessarily. So an incorporator could be, let's say, for example, for a private company, you need a minimum of one person. So in that, or one director. So in that instance, you are the incorporator. You have this idea, you want to start a business. Here is the memorandum of incorporation or the founding document. This is how you're going to run your business. You enter into a contract and you do all those legalities. So now when that company is being incorporated, the option is on you. For example, that's why you'll find out there are companies called shelf companies. Shelf company, there's an incorporator who's drawn up a business, who's drawn up documents, and then at a later stage, when they decide, okay, look, now I want to make this company active, they can either still, from being an incorporator, to be the sole director of that company, or they can sell that business to someone else. So sometimes they do that for instances when, let's say in the public sector, there is a tender that has been, advertised, and there is just no time for you to go through all the requirements of registering a company and so forth, and then you go to a shelf company and you buy that shelf company. So not necessarily an incorporator needs to be part of the board. They can either be part of the board or they can sell that company for a profit. So it just depends on the incorporator.
Okay, thank you.
Yes, thank you very much for the questions. And that was Yolanda, correct?
So can I just ask something else? If the company is incorporated and the company decides that they don't want to go ahead with the contract,
Yes.
then the persons who did the contract in the beginning, will they also be, their liability won't be there anymore?
The crux of your question is when do they give notification to the landlord that they do not want to carry on with the contract? And that's why we're talking about the 3 months.
Okay.
So we signed the contract today. We've got 3 months that we need to confirm to the landlord if we are rejecting or we are confirming with the contract. Let's say now it's 4 months, it's 3 months, it's 4 months, it's a day one of 4 months. We didn't confirm with the landlord that we did not incorporate or start the business. In that instance, me and you are jointly and severally liable for the liabilities of that contract.
Okay.
But if it's before 3 months, or let's say still on the 4th month, but the difference now, we did confirm with the landlord that we are continuing with the contract. Now the shift of the liabilities change. It would be on the company.
Okay. So that 3 months is vital.
Yes, the 3 months is vital. Hence, you will see on the solution on page 12, all those words in bold. Those are the keywords in answering.
Okay.
Yes.
Thank you
Yes.
very much.
Not a problem. Thank you very much. That is Ozona, right?
Correct, yes.
Thank you very much. Any other question before we move to reckless trading? I see there are no messages so far. So any questions before we move on to reckless trading? Okay, I'll take it there's no questions, but you're more than welcome to ask later on when we proceed. So now we are also going to touch a bit more in detail into reckless trading. So in addition, actually what what I didn't do was to go to regulation 35 of the Companies Act. Actually, let's go there now, which is I've got this document here. Let's go there now and see what regulation 35 says in relation to pre-incorporation contracts. Just want to see the page numbering here. This is 47, so it will be page 50. Okay, just before that. Okay, let's look at what the regulation says to pre-incorporation contracts. So it says here, see section 21(3). A person may give notice to a company of a pre-incorporation contract or action contemplated in section 21(1) by filing and delivering to the company a notice in form COR 35.1. That is just a document used by the CIPC that is for specifically pre-incorporation contracts. If the board of a company has completely or partially rejected or completely or partially confirmed a pre-incorporation contract or action of which it has received notice, as contemplated in section 21, the company must, within 5 business days, file a notice of its decision with respect to that contract or action in form of 35.2, or deliver a copy of that notice to each person who is a party to the contract or materially affected by the action. So what it says is, if regardless if you have partially or completely rejected or confirmed a contract, within 5 business days you must confirm that notice with respect to that contract, or you must deliver a copy to each person who is a part of the contract. Now this is you confirming now that the company is in existence. So this is in addition to the 3 months that has been given. So let's put it in practicality. Today we start a company, we sign a pre-incorporation contract. We have up till 30 days for us to confirm whether we're continuing or not with the lease agreement. We've got 5 days after confirming the existence of the company to confirm to the landlord that yes, we do have a company. Now this is in addition to now if we are going to confirm now later on in the 3-month period if we're continuing with the contract or not. So if you can maybe put it maybe for more understanding, this is sort of like a way of protecting the landlord. Let's put it into practical example. So you enter into a contract. There are 2 things. One, you can either instead of you as a landlord waiting for 3 months for them to confirm if they are continuing or rejecting with the contract. Let's say now it's month 2, the last day. Now they come back to say that we are not continuing with this contract. How much business would you have lost along the way because you had this pre-incorporation contract signed? And you don't want to be in a position where you sign so much pre-incorporation contracts that once everyone comes, to list the premises, that it's only one premise, let's say for 5 companies, you are avoiding to do that. So you as a measure, you are given the option to get confirmation from the incorporator that the company is in existence within 5 days of incorporation. So the incorporator needs to inform you within 5 days that yes, the business is in existence. Now, in that instance, I think then, it will just be courtesy, from other parties, to maybe still ask the questions, look, will you still be continuing with this? As much as I'm aware that you have up until this date to confirm, but, it's easier that way. And also, you don't want to run the risk of here now, when the contract is enforceable, they decided, look, we're still rejecting it, and the company will be liable for the debts of or the liabilities or the rent due for that premises, only to find out even so, the business on its own does not have any assets. So you as a landlord don't actually even have something to claim, because what are you going to claim? The business is just started, they do not have any assets. So it's sort of like a way of safeguarding you, as the landlord, of what should happen, when the pre-incorporation contract is signed, and also when the incorporator has registered and the business is in existence. As I said, those forms, COR 35.2, those are the forms used by the CIPC. Actually, what we can do is, since we talked about being active, let me go and check that form. I'm just going to search for COR 35.2. I'm going to share my screen now, just a second. Just waiting for it to completely download. Okay, let me share my screen again so that we can just have an idea of what the form is. Okay, so that is the form, as I said, COR 35.2. So it says here, notice of action concerning a pre-incorporation contract. So the date, the customer code. The customer code is sort of like, a reference for the company. Then from the name and registration number of that company, and here the company named above advises that it has completely or partially rejected or completely or partially ratified the following contract entered into or action taken in the name of or on behalf of the company before the company was incorporated as contemplated in section 21, and then you will list the details of the landlord there. So, and then the name and title of person signing on behalf of the company, authorized signature. So now here, this is where you will be confirming that you will either be completely rejecting or ratifying or confirming the specific contract with the landlord. So remember with this, as much as I said that where it says here, if the board of a company has completely or partially rejected or confirmed a pre-incorporation contract which it has received notice, meaning that it has been made aware, the landlord asking the pre-incorporator, they must within 5 business days file a notice of its decision with respect to that contract or action using the form we've just went through, or you deliver a copy of that notice to the landlord. So now this is the landlord asking within that time, within those 3 months, after now the business has been incorporated, I'm asking you, are you still confirming or rejecting? If the other case, they must confirm and give you feedback within 5 business days. Also remember, maybe another point of worth noting regarding the time. So it says here, the 3 months we talk about, it doesn't say, 3 months as in including business days or it's a calendar month. It just says within 3 months. So it will be 3 months from the date that the contract was signed. So if it's on a Sunday, that will be day 1, which will end, let's say if day 30 is on a Saturday, it's a Saturday. Not to say we signed the contract on Sunday, but it's only Sunday, the 6th of September. The contract date or signing date is only beginning October. No, we look at the date exactly. It was signed from that date and 3 months into the future. Any questions before we move to reckless trading? Or you can pop a question on the chat and then I can take the question later on. Let's look at reckless trading. So this is when we spoke about, a director recklessly getting into contracts on behalf of the company, although a sensible director would not get in or would not sign, that specific contract, if they were in good state. But let's look at what the Companies Act is saying. And there's no regulation for this one. Let me just confirm here. Yes, there is no regulation for this section. So it says here, a company must not carry on its business recklessly with gross negligence with intent to defraud any person or for any fraudulent purpose or trade under insolvent circumstances. If the Commission has reasonable grounds to believe that a company is engaged in conduct prohibited by subsection 1, the Commission may issue a notice to the company to show cause why the company should be permitted to continue carrying on its business or to trade as the case may be. If a company to whom a notice has been issued in terms of subsection 2, which is above, fails within 20 business days to satisfy the Commission that it is not engaging in conduct prohibited by subsection 1, the Commission may issue a compliance notice to the company requiring it to cease carrying on its business or trading as the case may be. Let's use Steinhoff as an example where one of the directors, I just forgot the name, there were allegations that he entered into business, while, the business was seen as trading insolvent or, fraud allegations, gross negligence, intent to defraud the company. So as much as I don't recall specifically reading it, on the media that, this notice was issued, but basically what it says is, should the Commission be aware, now the Commission of the Companies Act, should they be aware that the issues contained here in section 21A, should they be aware of any of those issues there, then they do have a right to issue a notice to the company showing cause why the company should be permitted to continue carrying on its trade. So now in that instance, that company is given 20 business days to satisfy the Commission that actually we're not trading insolvent, we're not acting gross negligently or recklessly trying to defraud the company, and these are the reasons why we say so. And then the Commission in that instance will advise, if they are complying or not complying. So remember, this is all about the Companies Act. Are you in compliance with the Companies Act? So if they can see this company was actually opened, to defraud, let's say, for example, parastatals or to defraud its companies, then the Commission has a right to stop that company from carrying on trade if it feels that, wrongful intent is being done by the company. Any questions before we actually look at an example as well for reckless trading? Any questions? Okay, let's look at activity 2 on page 13. This is with regards to reckless trading. The following is an extract from Distilic Limited's annual financial statement as at 30 June 20X. The assets were given the total non-current assets, we're given the total current assets. And for liabilities, we're given the total non-current liabilities and the current liabilities. Actually, let me stop doing some talking. Witness, just for making sure that you are still on the same page, please confirm how would you do a solvency test for this example? And I can see Mabato, you online. So please let us know how would you do a solvency test on this example. So your starting point is, what is a solvent test? What does it entail? And then you can apply it to this activity. Okay, Kaylin, let's give it a try. And I'm making notes on my side here. If I'm not getting any response, I'm still going to ask further questions.
I don't have the example.
You don't have the example?
No.
Oh, sorry, just to make sure, like, you don't have the study guide.
I don't.
Okay. Okay, look, in this instance, should you not have it, please do go to my UNISA under this module code. You should be able to download the study guide. If not, as I said earlier, or when we started the session, you can send an email to citntat@unisa.ac.za if you cannot get it from there, and then they'll be able to assist you on that one. Is that fine?
Okay.
Okay, thank you. Alzona, let's try you.
Okay. For me, the solvency test is where you look at your total assets and your total liabilities and the fair value of that, and your assets should be more than your liabilities for
Correct.
you to be solvent still.
Let me help you there before you go and apply that. So for solvency, if you remember, I said it's for long term and liquidity is for short term. So I want you to be specific. When you say assets, for solvency, we are talking about non-current assets, and for total and for liquidity, we're talking about, no, sorry, for solvency, we're talking about current assets, and for liquidity, we are talking about non-current assets, the short and the long term.
Okay.
Yes. Since I've given you that, can you give us the application?
Okay, so if solvency you said isn't the other way around? Liquidity isn't short term. The current assets.
Current assets. Yes, current assets is for a period within 12 months, and non-current assets are for the long term. Did I say the other way around? Apologies.
So for your solvency test, you'll take then your non-current assets, which is 4 million, and your non-current liabilities, which is 6 million. So your non-current liabilities is more, which means they won't be able to pay that. And then on the short term, your current assets is 2 million and your current liabilities is 5 million, which is also in excess of your current assets, your current liabilities.
Yes,
So,
actually, it's the other way around. Current is short term and non-current is long term. I'm not sure if now I'm what's this? I'm confusing myself. So current assets or current liabilities is now in the short term, and non-current are for the long term.
yeah.
Sorry, also the solvent, I wanted to know which between the solvency and liquidity, which is short term and which is for long term.
Solvency is for long term, and
okay.
liquidity is short term.
Okay.
So liquidity. So what liquidity says is, if we actually look at the definition of it, this is page 6 on that table on diagram 1.1.2. Liquidity test. It's will the company be able to pay its debts as they become due in the ordinary course of business for a period of 12 months after the date of the test? So that is basically within 12 months. That is your short-term obligations. And for solvency, as you can see there, even with the description, it says assets fairly valued are equal to or exceed liabilities of the company or group of companies. That is the long term. So remember, when you buy an asset, you don't buy an asset now, you don't buy a building now to trade only to find out that in month 10 you want to sell it. That is not part of your operations, except if, for example, you are a property lender or a developer. Are we on the same page? So let me go to the exercise.
Sorry, can I? Oh,
Yeah.
Oh, I was about to ask something that had to do with the exercise.
Yeah.
Solvency, you are weighing, well, you are seeing whether your assets cover your liabilities, right?
Yes.
Do you take your current, non-current, or do you just take the total amount?
you will not take the total amount. So remember, for solvency, we're looking at assets and liabilities over the long term. So
Okay, over the long term. Okay.
yes, over the long term,
So
and then
your non-current assets and your non-current liabilities.
liabilities, yes. And then with your current assets and your current liabilities in the short term. So remember, if you look at the individual transactions for current assets, that is, for example, your bank, your trade receivables, or which we call them debtors. Under your current liabilities, we are looking at your creditors or trade payables. We are looking at your short-term finance loans. So those are the stuff that happen or you are supposed to pay within a 12-month period to confirm if you are liquid or not. Are we on the same page?
Okay.
Yes, so it's fine. Thanks for the attempt, Elzona. Look, it's these instances where we'll also try to see if, for example, we are, not reading correctly or understanding incorrectly. Let's do the exercise. We will go into the detail of how we confirm if either they are solvent and or liquid. Feedback on activity 2. So it says here, so you can see the way they answering. It first starts off confirmation of the section. According to Section 22 of the Companies Act, a company may not carry on its business recklessly with gross negligence with intent to defraud any person or for any fraudulent purpose. That's 1 mark. If the CIPC, which is the Companies and Intellectual Properties Commission, has reasonable grounds to believe that a company is engaging in prohibited conduct as stated in the above paragraph or is unable to pay its debts as they become due and payable in the normal course of business, the Commission may issue a notice to the company. The company will then have to give reasons why it should be permitted to continue with its business or with its trade as the case may be, what we've said earlier. Should the company fail to satisfy the Commission within 20 business days, that it is not engaging in conduct prohibited by the first paragraph above, or that it is able to pay its debts as they become due and payable in the normal course of business, the Commission may issue a compliance notice to the company requiring it to cease carrying on its business or trading as the case may be. So part of answering your question, you start with the Companies Act. Specifically with this section, this is what it entails. You don't necessarily have to summarize everything as long as it's in line to what is being said, what we've just said now. And with the application, it says here, in this instance, the Stilic Limited will not be able to satisfy the Commission if it receives the notice indicated above because of the following. Now we get to the crux of what our Zona. Distilic Limited does not satisfy the solvency test since after considering all reasonable foreseeable financial circumstances of the company, the assets, if you can page through the assets, what were they? Of the company were fairly valued, do not exceed the liabilities of the company, fairly valued. So I think
See, there they took the total. That's why I was
yes.
asking.
Oh yes, I think that's why also Elzona, or was it you or Elzona who asked it?
Yeah,
It
I
was
also,
me.
yeah.
Yeah.
Okay, so as confirmation, we look at the total assets and the liabilities before we look at liquidity in separating or going into detail of the assets and liabilities. Apologies for the miscorrection on my side. Looking at the second one, we'll go through the exercise to the previous page again now. So Distilic Limited is not liquid since the current liabilities exceed the current assets. Distilic Limited is trading recklessly. It is therefore in contravention of the Companies Act. So let's start with the liquidity, where we said the current liabilities is 5 million and the current assets is 2 million. So basically what it says is, let's say for example we have current assets, which is now also be specific, we have current assets of 2 million. Let's say those current assets is plant, equipment and machinery, and then our current liabilities is 5 million. let's say the 5 million is pertaining to a loan we got to pay for those assets. As of today, if we decide or the commission serves us notice that we should close the business, the question to ask is, will we be able to pay off our debts? And in this instance, the answer is no. This is also done in relation as a figure. So if you take 2 million, divide by 5, let me just quickly do that to get a percentage. Sorry, I'm just getting my calculator here, because sometimes this is expressed as a percentage 2 divided by 5. So that means that the
4%. I mean, 40%.
40%. Yes. So what it basically means is, should the company cease to exist, we will only be able to pay 40% of our debts or liabilities. That's why then we are saying the business is not liquid. When it's liquid, the assets must be more than the liabilities. Going once.
Sorry.
Yes.
Oh, sorry. I just wanted to ask, when you answer, when you do your application section of the answer, do you form your question the way they did in the study guide, or can you also use ratios or percentages?
Look, you can still use ratios or percentages. The only thing they really do here, also because remember, percentages and ratios, for example, if we're doing a financial maths, session, then those would come into play. But giving you, just in a case where it's asking the question, what is the percentage? Then in this instance, you will be able to do it and not say current liability, current assets is so much, current liabilities, current assets is so much, current assets is so much, current liabilities is so much. If you are specifically asked in a question, express it as a percentage, then you will be able to express it as a percentage. So what you can do is, let's say for example, you still answer the same way, that we are saying that it's not liquid because the current liabilities exceed the current assets. You can put in brackets, for example, only 40% of the liabilities will be paid should the company cease to exist as of today, for example. That is you now also knowing how to apply even that that test if liabilities are greater than your assets. It can also be a point form as well, where on the left side you've got 2 million, on the right side you've got 5. What will be the equation? It will be 1 is to, let me do this here, which will be 5 divided by 2, 2.51 in relation to 2.5, meaning for each asset you own, you owe 2.5 to that asset. That is another way of expressing it instead of it being a percentage. You can also express it as a ratio. So here they do not specify which way you should do it, but as long as when you're giving the solution, you do make mention of the amounts.
Okay, thank you.
Yes, okay, thank you. And then let's go to the one before that, where we confirm that the solvency test, we look at holistically the total assets and the total liabilities. Looking at the example, our total assets, it's 6 million, our liabilities, it's 11 million. So that means that should we cease to exist today, we can only pay our liabilities 6 million and have a shortfall of 5 million. So that's why we are saying that we are also not solvent because of that case. Also remember, this could be vice versa. We can still not be solvent, but for our day-to-day operations or within the 12 months, we will be able to pay our current liabilities. For example, let's say our current assets was 5 million and our current liabilities was 2 million. In that instance, we are able to pay, we will be able to pay our liabilities should we cease to exist today. Any questions or clarity? And in that instance, you get your 6 marks. So first 3 were given to the theory, and the next 3 were given to the application. Actually, 4.5 was given to application, but question only allows up to 6 marks. Any questions before we go to records required by companies for the last 30 minutes?
When giving the theory part, does it have to be word for word, or could you somewhat summarize it?
To be honest with you, is it Kaylin? To be honest with you, I wouldn't, as a lecturer, I wouldn't expect you to know word for word, because remember, you've got section 21, you've got section 22 for reckless trading. Or now we're going to look at records required by companies, section 23 to 29. And there's another section from 30 to 31. You won't know all the sections by heart, but the crux of the sections is to know the keywords. Like, for example, with reckless trading, you need to know that you must either confirm or reject the contract. That must be done within 3 months. What will happen if you don't confirm it? What will happen if you do confirm it after the 3 months has passed? Those are the bases that you should know. What we can also do is, let me look at the study guide, sorry, the TAT letter, to see if there is a question that they've asked, and see, for example, how it's asked in the assignment. So I'm looking for assignment 1. This starts on bottom of page 25, and we are doing topic 1. Okay, so there's, okay, okay, look at page 28, number 7 of the TAT letter. I'll read for those who don't have the TAT letter now. So it asks here, which of the following situations is in compliance with the requirements of the Companies Act 71 of 2008 as amended? The first one says the shareholders meeting of Mentalis Limited held on 30 June 2019 was conducted successfully. As per the minutes of the meeting, a voting quorum of persons holding 30% of, okay, actually this one relates to topic 3 when we talk about shares, voting rights. Let's pass that one. Let's go to number 2. NCIS Limited was newly incorporated on 30 June 2018. The date of the first financial year end as set out in the company's notice of incorporation is 31 August 2019. The first AGM, okay, actually this one is also, let me see here. Okay, actually, yeah, it's more on topic 3. I wanted one where it was specifically asking a question in relation to topic 1 about reckless trading or pre-incorporation contracts.
Question 17.
Question 17. Okay, let me look for question 17. Oh, okay, let's see here. Which of the following situations might constitute reckless trading in terms of section 22 of the Companies Act? This is topic 1. Company X is factually insolvent. The directors of the company subsequently decided to take out a rather large loan from ABC Loans in order to improve Company X's financial position. Yolanda, can you give us the go-ahead with that question there? What do you think the answer is? Does it constitute reckless trading?
Number 1.
Yes.
A large loan to improve the fund. With number 1, I disagree, because how would more liabilities improve the company's financial position? So I think number 1 would constitute as reckless trading, but I haven't looked at the other options yet.
No, it's fine. Any answer, we can work on it. Elzona, which one do you think? Do you think it's reckless trading there for number 1?
Yes, I also think it's reckless trading, because if you can't, if your assets already or your liabilities already exceed your assets, why would you then go for more loans to try? And because you, at the end of the day, you still need to repay those loans. And if you can't,
that is correct. And actually, it's here we're given that they are factually insolvent, meaning that they can't pay their liabilities. They wouldn't be able to pay their liabilities with the assets if the company should cease to exist. So actually, as you've said, why should they go for more loans? Whereas, even if it's trying to improve the company financial. So remember, taking out a loan, you're increasing bank, which is part of assets, but you're also increasing liabilities, which is part of creditors. That cancels out each other. So, but we are told that they are factually insolvent. Just like with the next two, or actually next three, if I could call it, company X is factually insolvent. 3 of its directors embarked on extensive overseas trip as part of their annual bonuses. Company X is factually insolvent. The company, however, entered into a lease agreement for a very expensive fleet of company vehicles for its directors. And my
Yeah,
answer, and
I
my
think
answer
all of
also,
them.
yes, they might constitute reckless trading. I also do agree. So, in a case of short questions, this is how it would be asked. If it's application, it would be similar to the example that we just did. But also, it's nice that we actually went to go to the assignment to see how it's asked and what would be expected to be asked. Any further questions? I think, if I'm not mistaken, there was a question, or maybe did I answer it by actually giving the answer that I just gave now? Okay, let's move on.
Oh, sorry. Someone did ask about writing the answers word for word, and since you're quoting the act in most cases, is it okay if you write it the same but by changing, like paraphrasing, basically?
Sorry. So actually, paraphrasing is preferred because remember when you writing word for word, basically what you've done is you've crammed. And the only way for you to understand, if you do know the content, is explaining it your own way. So you don't necessarily have to write it word for word. As long as it's in line to what has been asked. Like as I said earlier, those keywords must be there. For example, pre-incorporation contracts, you must have you must talk about the 3 months. You must confirm or reject the contract. So as much as its application, the theory part of it, it's you noting that yes, this is contained in the act and this is what the act says. For reckless trading, if you defraud the company, you act into a contract negligently, then the commission may issue a notice to the company and you must give response within X number of days and so forth. That is you now confirming that you do understand, or you do understand the interpretation of the act. Are we on the same page? Okay, I think what we need to do is now, let me quickly do this here. Anyone feeling for a break? Okay, let's continue. So what I will do is now I will quickly share this, or actually before sharing it, let me first go to record keeping, which is not a lengthy session, before I go to the article that I got from MoneyWeb regarding the solvency test. Okay, so what we're going to look at now for the next 25 minutes regarding external companies, registered offices, and company records. It will be on the Companies Act. And we're going to look at record keeping and financial statements, just a brief. We won't look at exactly the whole terminology, and then we'll be done for today's session. Let me go to the Companies Act. Starting on section 23. Why is it doesn't want to show up now? Just a second, I'm just battling to share this file. Sorry, it's just been going away when I click on it. Sorry, just bear with me. Okay, finally, there we go. Okay, thank you. So what we're going to look at is sections 23 up to 28 regarding subparts about transparency, accountability, and integrity of companies. So this will be from page 17 up to page 22 of the study guide. So let's start with the registration of external companies and registered offers. I'll touch on a few. So it says here, section 23, an external company must register with the commission within 20 business days after it first begins to conduct business or non-profit activities, as the case may be, within the Republic. So this is a case of an external company. Let's say it's a company that is from the US. They want to operate in the country. They need to inform or register with the commission within 20 business days after it starts conducting business for non-profit activities as an external non-profit company, if within the jurisdiction in which it was incorporated, let's say now in the US, it meets legislative or definitional requirements that are comparable to the legislative or definitional requirements of a non-profit company incorporated under this act, which is the Companies Act, or as an external profit company, if within the jurisdiction in which it was incorporated, it meets legislative or definitional requirements that are comparable to the legislative or definitional requirements of a profit company incorporated under this act. So basically what it's saying is, regardless if, let's say this company was registered in the US, either as a non-profit or a profit company, if it conducts business in the Republic of South Africa, it needs to register with the Commission within 20 business days after its first conducting of business or for non-profit activities, as long as the legislative requirements in the US are the same as contained in the Companies Act. So let's say, for example, for non-profit organizations, these are the requirements. If they meet those, then they can be able to conduct business in the country. Let's look at number 2 as well. For the purposes of subsection 1 and the definition of external company as set out in section 1, a foreign company is not to be regarded as conducting business or non-profit activities, as the case may be, within the Republic, unless that foreign company is engaged in or has engaged in on one or more of the following activities within the Republic. So conducting business, you need to confirm those things there. For example, let's say you held a meeting of the shareholders or board of the foreign company, or otherwise conducted the internal affairs of the company in the Republic. So you'll be regarded as conducting business. Because conducting business could be you made a sale, online. Is that conducting business? Part of it, if the client or the customer is South African based, that means you have conducted business in the Republic. Then you do fall part of the definition of conducting business. And so on gives other examples. Let's look further down, let's also look at number 6. So remember, I'm skipping some of them because it's just in addition to what I've touched on, or it's more specific to a certain task. Subsection 6 says, if an external company has failed to register in terms of subsection 1 within 12 months after commencing its activities within the Republic, the Commission may issue a compliance notice to that external company, requiring it to register as required by subsection 1 within 20 days after receiving the notice, or if it fails to register within the time allowed in paragraph A above, to cease carrying on its business or activities within the Republic. So basically, an external company has got up to 12 months to register with the Commission that they are doing business in the country. If it's an external company, they are given 20 days after receiving that notice. Now, this is after they've been known that they are conducting business in the country, but they're not registered. They will be given 20 business days to register after receiving that notice, or if they fail to register, then they will need to cease existing in the Republic. So the first section about external companies is basically, if it's an external company, profit or non-profit, by when should it register within the public? If it hasn't done that within 12 months, after giving notice within 20 days, they need to register on or cease to exist in the Republic. Looking at 24, forms and standards for company records. So how should we keep company records, in which form? Section 24, any documents, accounts, books, writing, records, or other information that a company is required to keep in terms of this Act or any other public regulation must be kept in written form or other form or manner that allows that information to be converted into written form within a reasonable time. That's why, for example, let's say you conclude a contract over the phone, you are told that should you want the recording, it can be provided to you within, I think, 7 days. That is just apologies for that. My laptop just froze. I don't know what happened. Let me continue with the presentation. So I was starting on section 24. How should we keep the forms and standards for company records? as I said, even if it's telephonically, you can request a copy of that phone call. Let's look at subsection 2. If a company has existed for a shorter time than contemplated in subsection 1b, that is, if they haven't existed for a period of 7 years, the company is required to retain records for that shorter time. I think I didn't touch section B. So section B says you need to keep records for a period of 7 years or any longer period of time specified in any other applicable public regulation subject to subsection 2. So subsection 2 is if the company existed for a shorter time, then you must keep the records for that shorter time. I know, for example, in the finance services industry, you need to keep records for a minimum of 5 years. Specifically with the Companies Act, it says that for a period of 7 years minimum or any longer period as seen fit by the company. Subsection 3, every company must maintain a copy of its memorandum of incorporation, which is the founding document of the company, a record of its directors, copies of all reports presented at AGMs of the company for a period of 7 years after the date of any such meeting. They must keep annual financial statements, accounting records, notice and meetings of all shareholders' meetings, any document that was made available by the company to the holders of securities in relation to each resolution. For example, if securities we mean shares, if you are a shareholder, any communication that was done to you, they need to keep records of that. So basically, keeping records, you need to keep records of basically every transaction that the company enters into for a period of 7 years or as contemplated by any other legislation. Also including the minutes of any meetings that were had, directors, secretaries, any resolutions, any minutes of meetings, those need to be kept in the company. It all depends. The company can keep those records in the same premises, or they can have an off-site location to keep those documents. For example, you'll find out there's a main branch in, let's say, in the city, and then they always have an off-site, let's say maybe 50 kilometers away from that area, so that even if, for example, the whole city for some reason burns down, they always have that information, from afar. For example, also number 5, it says company records of directors must include in respect of each auditor. Now this is just additional information, the full name and surnames, ID numbers, nationality and passport. So basically all the client or director details, they need to be kept. So that's how the forms and standards of company records should be. Main crux, they should be kept for a minimum of 7 years. Location of company records I just touched on a bit. The records referred to in section 24 must be accessible at or from the company's registered office or another location within the Republic. A company must file a notice setting out the location or locations at which any particular records referred to in section 24 are kept from, which are accessible if those records are not kept at or made accessible from the company's registered office or moved from one location to another. Basically, what it says is if the records are kept at the registered office, sorry, I pressed the mute error. So if the records are normally kept at the registered office and they need to be kept elsewhere, a notice needs to be filed that the records will be kept at another place, and also the company records must always be accessible to anyone who needs records of. Let's say, for example, you are the shareholder, you're requesting a minutes of a meeting. Let's say you were supposed to be in that meeting, you were not there, or you want specific minutes of a meeting that happened in the past. You should be able to get those documents within a reasonable time, and it's in either form, either in writing, or you will have to physically see them, Also, another thing with company records is, for example, with the registration certificates, they always need to be shown in the registered office of the company, confirming, that they are registered. You'll find out, for example, even if you go to shops, specifically food shops or outlets, they always have a certificate confirming they belong to this certain industry. They belong, let's say, maybe to the Halal Association, they are registered, the certificate is valid until this time, information like that. Access to company records, touched on a bit. So any person who holds a beneficial interest in any securities issued by a company like shares has a right to inspect and copy the information contained in the records of the company. They have the right to any other information to the extent granted by the Memorandum of Incorporation. So remember, the Memorandum of Incorporation, it gives confirmation on what can and cannot be done. So if the Memorandum of Incorporation specifically says that a shareholder cannot have access to the executive committee minutes of the meeting, then if you are not part of the executive committee, you cannot get a copy or see those minutes. So so basically, access to company records, you should have access to them, as I said, either to the registered office or any other location, and in particular, it must be in accordance with the Promotion of Access to Information Act. That is, if, for example, you are requesting director information, the company must not willingly give it to you. That is part of personal information. The director should give confirmation that they do give access for that to be done, then that information will be given to you. So the other is just for more clarity. Financial year for a company basically says that a company must have a financial year end ending on a date set out in the company's notice of incorporation. So remember, when you're starting a company, part of the process is you need to confirm this is the financial year end of the entity. So it's just confirming that. The first financial year of a company begins on the date that the incorporation of the company is registered, as stated in its registration certificate. So the 7th of September, we incorporated the company. That is the start date of the company. We can have a final end of year as at 31 December. That is up to you. So basically, you'll be trading for this period, or you can have it up to tie with the tax year. You can also do that. So you can always chop and change. But if it's not a full year for the first year, that's also fine. So also with that one, it just gives more information. Section 28, accounting records. A company must keep accurate and complete accounting records in one of the official languages in the Republic. Basically, that's what it says. It must be kept in the accounting records of the company. If the Memorandum of Incorporation does stipulate that it needs to be audited, then an auditor needs to be employed. That is also contained as, which will be part of homework, page 19, the requirements to be audited or independently reviewed. I will touch on it again before we move to the next session. And then financial statements, also similar to accounting records. How should we keep financial statements? What should the financial statements contain? For example, they should satisfy that the financial reporting standards as prescribed. For example, it's according to the International Framework for Reporting Standards. That must be confirmed. They presently fairly state the affairs and business of the company. They show the company's assets, liabilities, and equity, as well as its income and expenses, and any other prescribed information. So basically, what generally is contained in a financial statement, and you can read all the rest in addition to what I've just introduced. Annual financial statements, basically financial statements is on month to month. Annual financial statements is yearly in relation to the section we touched on, that the company must have a financial year end. So come financial year end, within 2 to 3 months, the company prepares annual financial statements, either to be given to the public to see if it's a public company, especially those listed on the JSE. If it's a private company, chances are you won't be able to get a copy of it. But here it says each year a company must prepare annual financial statements within 6 months after the end of its financial year, or such shorter period as may be appropriate, to provide the required notice of an AGM in terms of section 61. And then it gives the details how and what it should contain. You will remember that with SAA, I think the last time they provided annual financial statements was in 2017. As much as there would be issues of fines given to SAA, I do not know how far it goes when it comes, for example, to paying a fine. But I do know that they have not been providing annual financial statements for quite some time now. Hopefully things will change as a new regime will start with SAA, just additional info. So also remember, as I said, this is in much detail to what the study guide has been given, which is sort of like a brief summary. And the last one in this section is access to financial statements or related information. Basically, what I touched on earlier, related information could be who are our suppliers, where are we trading, in which countries, what are the laws of those countries. You can request that information. There is a first part of the registration of external companies, the offers, the forms of standards of company records, access to company records, financial year, and accounting records. Now, just lastly, to go to record keeping and financial statements. Record keeping and financial statements, this section, 29 to 31, which is I've just covered. And in relation to that, there is a table on page 19. Table 2.1.2, requirements to be audited or independently reviewed. Please go through that. You will have a look at it again when we do our recap for next week. In conjunction with up to page 20, yes, up to page 20. So you'll notice that when you read through that table, it talks about a score. That score or public interest score is given detail on page 20. That is diagram 2.1.2. So to confirm as the reading, table 2.1.2, requirements to be audited or independently reviewed, in conjunction with diagram 2.1.2, where it's given introduction or what a public score is. Also do activity 18, which will give activity 18 on page 20, which will ask questions regarding the sections we've just covered. Activity 2 is asking about the public interest score and how would you calculate it. That goes up to page 22. You will see there we are also given figures on how to calculate the public interest score. We will do that when we start the lecture next week. What I'm going to do is now I will just if you can give me 2 minutes, I will cover, or actually I will show the article that I had seen regarding solvency. Just quickly opening the article before sharing the screen. Okay. Okay, just give me a sec. It's opening now. So as I said, the article was just a commentary on the road accident fund, and further down the article it just gave the figures on why they are saying the road accident fund should be wound up, meaning that it must be closed. Whoever needs to be paid must be paid, and then closed down. I'm going to share it just now. Andisebenza kakubi shem. Okay, accept cookies. Okay, so as I said, this is an article from MoneyWeb titled "Move to Shut Down Road Accident." The High Court to wind up insolvent fund. I'm just going to go through these first two paragraphs. So it says here, the road accident fund stays could be numbered. This is if Maponya Attorneys gets its way, as it has applied to the Gauteng High Court for the state entity, which compensates victims of motor vehicle accidents to be wound up. And this is the crux of this article. Maponya, which was appointed to the funds panel in December 2014, says given the financial peril the road accident fund is in, a court-ordered winding up is the fairest outcome for all stakeholders. As things stand, the fund is insolvent as its total liabilities exceeded its assets by 262 billion, according to its 2018-2019 annual report. And the floor is all yours. You are welcome to give a comment on what that article says there on regarding the first session we had, or actually including the session we had regarding solvency. Any comments?
I don't understand, how do they accumulate so much liabilities? Or is it, or because I mean, from what I understand, the road accident fund receives the funds that it has to pay out to the people who claim from fuel, if I'm not mistaken.
Yes, correct. There is a levy that we pay towards the RAF. I don't know the exact figure, but yeah, there is a levy that we pay for road accident fund victims.
Okay, so is it because maybe that levy alone does not accumulate enough money compared to like the amount of claims that come in, or is there some sort of corruption inside? I don't know, like how do they get so much liability?
Look, I think we all have, we can have different opinions on what it says. So number one, actually what the article is saying, I will share it on the folder for this session. So basically what it says that actually while we're doing that, I'm just posting again to the meeting chat the attendance register and the link to the feedback form. You can do that so long while we just having a conversation here. So part of the article, what it says is number one, what could happen is they could increase the rate from the fuel levy. So for example, let's say if it was 1 rand, they want now to take 2 rand, but there are many consequences that could happen there. One, it's either the fuel price itself will go up, or if they're going to take that extra 1 rand from somewhere else, that means that place will be short of 1 rand, per liter of fuel. That's number one. Number two, it has the road accident fund in the past. Now this is just my own personal opinion. In the past, it has sort of like become a cash cow for lawyers, for registered fund lawyers, because when they claim let's say, for example, it's not a prescribed case as far as I know, where if you are run over by a car, regardless of the degree of your injuries, you are guaranteed to get X amount. That is not the case. There's always sort of like an application process that, look, this person was working, now they're disabled, they can't work, this is what they were earning. There's so many things to look there. So maybe as lawyers, they see it, as I said, as a cash cow to extort money from the government, to put in more claims, and the higher claims they put, the more money they're going to get as per their percentage, so it could also be that. But I think maybe the main crux of that article was generally, any government agency or parastatal is not run in accordance. We can make so many examples. So I think that's the one thing they would need to do personally, is maybe change management, and most probably things are going to change. I don't know.
How old is that article? Well, from when is it?
This money web.
Mm.
I took it, when was it? Yesterday. This is dated 4th of September. It was uploaded yesterday at 5:54 in the morning.
So
So it's a very recent. It's like, as in like yesterday.
yeah. So the records are from this current financial year.
Yes, 2018 to 2019. Actually, the previous
Oh,
financial year.
28. Oh, okay,
Yeah,
okay. Because I
2018
was
to
about
2019.
I was about to ask, because seeing there was a lockdown and everything, there were like lower reports of accidents and stuff. But I guess some claims date back to even before that. So yeah.
Yes, yeah. Yes. So remember, regarding the insolvency, it will be a case of, for example, let's say maybe from 2010 till now, when they sort of like did a sample of the article, actually finding out, if the road resident fund is solvent. That could be the case. But remember, when they're looking at their books, if the liabilities in 2010, it was already, let's say, 100 million, it's 100 million plus from 2010 up until now, you see. And actually, if you think about it, South Africa is a big country, accidents happens generally every day. There are some people who don't claim. There are people who do claim, like in the US. In the US, it's a new fashion where, people want to claim from insurance. They just, literally run in front of a car just to get a payment, So maybe those are things we as South Africans maybe need to do. Have make it a requirement to have dash cams on our cars. As I said, it's open. It's open, but I did share the article on the meeting chat, so you're more than welcome to go and have a look at it.
I had another question now.
Yeah.
Oh, what do I want to ask? Oh,
I wish I
is the
knew.
road accident fund a state-owned company, or is it non-profit? Which does it fall under?
I presumably think it's a non-profit, because it doesn't collect the fuel levy as a profit, but it collects the fuel levy to make payments towards road accident victims. So it's more like an agency.
Okay.
Yeah, so it's part of the Department of Transport, sort of like an agency of the Department of Transport, specifically responsible for making payments to road accident claimants.
So they
Yeah.
only generate the money from the fuel levy.
Primarily from the fuel levy, yes.
Okay. Okay.
As far
Thank
as
you.
I know, yeah, as far as I know. But
Yeah.
guys,
Well,
thank you very much for today's sessions. Just a recap, what we'll be doing next week, same time, we'll be touching on topic 3, and just to confirm, that will be, actually, I want to open my presentation again, so I quickly need to open here. Next week, we're touching shareholders and shares. What are shareholders? What are the type of shareholders, type of shares? what do we mean by a voting quorum, what it is. So we'll be touching that next week. So if you actually think about what we've covered so long, looking at topic 1, which was how to form a company, what is required. Topic 2, why should we keep records, in which format, where. Now we're going to look at the shoulders, the actual owners or of the business. We're going to look at that, and after that we delve into the directors. So if you remember, part of accounting records, we need to keep records of the directors. We are going to look at directors in more detail. For example, executive, non-executive directors, what are the responsibilities and so forth. Can a director make a loan from the company? We'll be looking at those things. So if there's any further questions, as I said, I did post a link to the register in the feedback form. You're more than welcome to give us feedback. We will treat it as if I need to change anything, I will do that. If I need to add, I will do that. And just confirmation, the homework that we need to do, we will cover that next week. Next week should be more lighter than today, but I just thought I had to do a recap for what we did last week, since it was the first lecture we had. So hopefully it did add some more information to you guys. And if there's anything else, thank you very much for your time, and hopefully I will see you again next week.